Locke, you are here first, so your case is gonna be taken care of first. Or did I just jinx that? I'm sorry. I jinxed him, didn't I? It's sort of like when you walk over somebody when they're laying down. They used to always say that's gonna mess with their height. And so you would have to walk back over them backwards. Oh. Vashawn got on us for splitting the pole. What will happen? I don't know.
I don't know. I want to find out.
What will happen if you split the pole?
Said stranger things about.
It's
Yeah.
bad luck, yeah.
Bad luck?
Yeah. Really? Probably why stuff is happening to me because y'all split that pole that day.
I will tell you what, to this day, I will not step on a crack. I refuse to be responsible for breaking my mother's back. Not gonna happen.
Either way.
Oh.
All day long you have good luck.
That is true, but you know what? When I see a penny on the ground, my mom would always say, "Don't touch that. You don't know what that's been." So I'm just like, "I'm sorry, Mr. Penny."
All money.
Oh,
Yeah.
that is true.
Please.
All right, it is almost 9 o'clock and I'll call the docket at 9. Oh, and we're gonna have some law students touring the courthouse in August, so we're gonna have to welcome them and let them know they've chosen a great profession. All right, it is 9 o'clock. I'm gonna call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm gonna assume you're not here and a warrant may be issued for your arrest. Emmanuel Moses Perez. Emmanuel Moses Perez. Troy Robert Mishler.
Present with counsel, Your Honor, briefly, Judge, there's a very specific prosecutor that's assigned to this case. I understand she's in trial this morning.
Okay.
So we'll await instructions from the court, but he is present.
All right, if you could pull that file for me, please. Vincent Arredondo, custody. David Edward Lopez. Isidro Garcia, custody. Alfredo Campos. David Escobedo, custody. Angel Miguel Cepedes Ronda. I know I'm mispronouncing it, that Cepedes, right? Okay. Angel Miguel Ronda Cepedes. Chase Anthony Lopez. Valerie Campion. Let me see, we have a couple of people on Zoom. All right. Yvonne Ardenez.
President, counsel, Your Honor.
Thank you. You said you would get her here and you did.
Thank you for the opportunity.
Sure. Joe Anthony Grant, I see you. Thank you. Valerie Campion. Adriana Ramos. Thank you. Carlos Perez. Corbin Samansky is by Zoom. Esther De La Fuente. Gage Ashton Guerra. Matthew Stephen Martinez. Fernando Raul Guzman. Fernando Raul Guzman. Lamar Simmons. Jeremy Lopez, custody. Valerie Marie Campion. Desmond Gomez, custody. Michelle Cruz Battles. Thank you. Amanda Stephanie Ellis. Amanda Stephanie Ellis. Elijah Rodriguez, custody. Jacob Hugo, is it Vicana? Vicuna?
Hugo Vicuña?
Thank you. I never, I'm always, no, he raised his hand.
No, that was not him. That's somebody else.
Okay. Thank you. Vincent Garza Arredondo, custody. Angus Akels, custody. Jacob Kawazawi, custody. Thank you. Jesus Enrique Alexander Velasquez. Jesus Enrique Alexander Velasquez. Pearl Gonzalez. Christy Rojas. Moses Ross. Thank you. All right, Mr. Ross, if you'll do me a favor and just take a seat in the box, please. And we'll see what the issue is, all right?
Yes, ma'am.
You may want to call your attorney. Deputy Laura, can you call his attorney while he's in the box? Oh, okay.
I think he has more cases in your court, actually.
All right, thank you. Dalen Newman, custody. Allison Lee Settle. Thank you. Dalen Newman, custody. Austin Young. Austin Young. All right, is there anyone who came in late or your name was not called? All right, yes, what's your name? All right. She knew right where to go on the second row. Sometimes that's a good sign, sometimes it's not. All right, so to the parties who are here, one, we're going to be starting a jury trial today on somebody's case. So if you want your jury trial, we'll make sure that you get your jury trial today. If you do not see your attorney here, you have the court's permission to step outside and call them, because we are recessing at noon and we're going to be doing jury selection at 1:30. Attorneys, these are the rules. Please follow the rules. You're not ready to approach the court unless you've conferred with the state and conferred with your client. Once you've done that, you may approach. The only exception is Mr. Locke. I know what your issue is. If you have someone who's an inmate, ask the deputy to have them brought out. Once you've requested that they be brought out, you do not leave the courtroom, because for security reasons, there are only so many inmates that the deputies are allowed to have out at one time. If your client wishes to speak to the court in a language other than English, we will need an interpreter, whether you speak the language or not. When we're on the record, please do not approach the clerk or the coordinator, and please do not speak behind the court reporter. If you are speaking with your client behind the court reporter and we're on the record, just raise your hand. The deputy will move them to the other end. We have Miss Abrams here. She is with probation. If your client is seeking probation, if there is an issue with probation, you need to make sure you speak with her. She's an integral part of the legal process. All right, it is Tuesday. The good thing about Tuesday is we made it. We survived Monday. So it's going to be a great day. Everyone, the humidity. Hey, this is Texas. People tell me all the time, they say, you're from Louisiana. You know about this heat. I'm like, no, this is different type of heat. You know, give me, in the words of aliens, give me some dry heat, you know? So the humidity is what the killer is. So everyone, please be kind to each other and you may confer. And then if I could see Troy Mishler. Yeah. So let me pull up Odyssey. Just give me a moment.
Yes, ma'am.
So what do you think is going to happen football season time?
For the Aggies,
Mhm.
8-5, like 3 year.
I'm like, please, please.
One of the best of those Coldplay memes that I saw, Judge, was the guy is behind the lady. It said Texas A&M, and the lady was sitting there and said 85. But lots of hope in the beginning of the season to get crushed. How are the Tigers going to do?
I'm telling you, if we could just, you know, if we could just get a coach, you know, for me, here's my thing about coaches in football. What is your specialty? Sometimes you have coaches, they say, oh, this offense is going to be running smooth because this is really an offensive guy. Sometimes you have somebody, they're like, oh, this is the defensive guy. They're going to shore up everything. I'm not going to say anything ill about the coach, but were championships won at Notre Dame? And you know what the problem is? A lot is expected, and maybe a lot should not be expected. And I always remind people, for me, talking about football and talking about different teams, especially college teams and the high school teams, it's just all fun and games, right? because at the end of the day, I still consider them children.
Right.
And every last one of them are doing the best that they can do.
And that's what makes the amateur, quote unquote amateurs more interesting
Yeah.
because they are 18, 19, 20 years old. There's some mistake that's gonna be made that's gonna affect the outcome of the game, but professionals, not so much.
I never will forget the coach telling the quarterback to spike the ball, and we didn't have any downs. This was our final down. And so he spikes the ball, and then people come to the coach, the Mad Hatter, like, oh, why did he spike the ball? Oh, I don't know. Dude, you were on the sideline telling him to spike that ball.
That
He
sounds
was
like
the
my-
one, he was the one like, hey, he's like, no. He's like, what? So, but I think we're gonna do okay this year.
Sure.
I usually know how the offense is gonna run by the plays that are called in the
Yeah.
very beginning. All right, we're chatting because Odyssey is taking a while, and I have to put everything in Odyssey. It's required now. All right, so on this case, do you have all of the discovery?
We do, Judge.
Okay. And has she tendered an offer or no?
We have an offer. We're going back and forth on that, Judge. Today is the plea deadline. But because she's in trial, I don't think we're in a position to submit that to the court.
All right,
So
we're gonna extend your plea deadline date, and this will be the final plea deadline date. All right. Let me see. Excuse me, does anyone remember the special prosecutor on Mishler?
It's Miss Crespo.
Oh, okay.
It's Miss Crespo.
All right, did she say she was gonna be on vacation at some point?
Yesterday. And the day you gave her was August 4th, I think, and she said she not to send someone else.
I know her schedule because we've been talking quite a bit. She's in trial this week, Judge, and then the next week she's out. So our opportunity to talk and nail down the moving parts would come presumably after she's back,
And when is that?
after next week. So
The week of August 4th?
The first is Friday,
Yes.
so that would make, she'll be out that next week, so it'd be the second week of August is when she's back, Judge.
All right, this is an old case. And I know it's not an old case in the sense of when it was indicted,
I understand.
but this will be your final deadline date. There will be no further extensions. So you all have to confer off record. Norma, can you put this for August 12th as a final deadline date? Will you be here or no?
I'll be coming back from Louisiana that day, Judge, because we're moving my son to Tulane.
Look at you. I should hold that against you. LSU is right down the road and you're doing Tulane. Okay.
So if I could just have even a few more
What
minutes.
do you feel about Tulane as opposed to becoming an Aggie?
I think it's a good fit for this. For my younger son, it's a great fit.
Awesome. So when will you be back?
We'll be back the 12th.
All right. So Norma, set this for August 14th.
I'll be here, Judge.
All right. Safe travels.
Thank you.
Once you sign the reset form, you're excused.
Thank you.
All right, thank you.
Critical fiasco last time we were here.
I remember that.
I was not here for that. Thanks.
All right, who's here on Lamar Simmons?
I am, Your Honor. I'm covering that for Joanne De Hoyos.
All right, are they on bond or in custody?
I verify they're on bond, and prior to putting bond, I had done a backfill letter to the jail.
Mhm.
I know he's with the company bond. We faxed a letter to the jail. There's no way, couldn't get that letter with our contact information, and we scheduled a jail visit. But I don't believe it showed to that. I don't have my laptop with,
All right. And so, and the bondsman has no idea?
If you would like me to.
I mean, do you want to call them to check in with them? And then, or if you want it heard now, I'll hear it now.
I can call in, but I would have to come back later this morning, fairly busy.
Sure. Okay. And just make sure it's before 12.
Yes.
Okay.
A action mailbox.
All right, they're gonna come back on that one. Adriana Ramos?
Mr. Sullivan present, Your Honor?
Yes. All right, so there's a motion to withdraw?
Yes, ma'am. She called me yesterday evening. She wanted me gone, and that's fine. She wants a new lawyer. I hope the court can give her one.
Well, I mean, is she gonna hire an attorney?
No, no, ma'am, that's not what happened.
All right, what's going on?
I had to call the MAC number yesterday for the second time. I've been having many problems with Mr. Boyd. He's very unprepared when we come to court.
Mhm.
The
Well,
first,
just 1 second, let's do this. So I'm gonna have you remain, and I'll have managed to sign counsel come down.
what does that mean, ma'am?
Oh, the MAC attorney is gonna come down,
Okay, yes, ma'am.
so they can see what's going on here.
Yes.
All right, thank you. Just have a seat, okay? All right, Norma, can you have managed to sign counsel come down, please?
Yeah.
Thank you. Norma, this courthouse tour, I've already responded to it. I told them we could have the courthouse tour, but it has to be before 10 because of the mental health. Hi, how's it going? You too?
Here with Mr. Locke.
Okay.
My lawyer.
All
Okay, Dejan.
right, you too. Court is calling 2025 CR 00539 State versus Adriana Ramos. Could I have parties announced, please?
That's all, Ms. Miles.
Adriana Ramos.
All right, so it is the court's understanding that your attorney has filed a motion to withdraw. Are you aware of his motion to withdraw?
Yes.
All right, so I don't do ex parte. However, managed assigned counsel just sent an email to the court coordinator, and the court is in receipt of that. Any objections to the court reviewing what managed assigned counsel has sent?
No, no.
All right. All right, so the email that has been sent to me, and I want to explain to you, Ms. Ramos, normally I do not allow motions to withdraw just because there's some sort of lack of communication, but based upon what managed assigned counsel has sent, I will grant the motion to withdraw. All right, you may be excused.
Be available for the next council with any questions, John.
All right, if you will just remain in court.
Y'all will.
Thank you. So then the next question becomes, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Amen.
All right, you can lower your hand if you'll state your name for the record.
Adriana Ramos.
All right, so Ms. Ramos, the questions I'm going to ask you, it has absolutely nothing to do with the facts of your case. Please do not tell me anything about the facts of your case because your attorney would not want you to, okay?
Yes, ma'am.
All right, so are you able to afford a new attorney?
No, ma'am.
All right, do you have any funds in a bank account, any savings?
Not really. My mom just passed away in May, so I just had to bury her.
Okay.
I do have a job at AutoZone, but it's part-time.
Okay, so do you have any money in a savings?
No, ma'am.
All right, so I'm going to have a new attorney appointed to you, and that new attorney is going to be Orlando Castino. All right, so if you'll confer with him.
Yes.
All right, she said today, we're off the record. She says today for a it's just discovery today.
Okay.
So that's what we're here for.
Okay.
So he'll confer with you, and then he'll confer with the state, and then he can approach me when you're ready.
Yes, Judge.
All right, you're welcome.
See you outside.
All righty. I'm gonna give this back to you, but don't follow the way they're gonna approach when they're ready. All right. So everyone else, if your attorney is not here, you need to pick up the phone and call them because we're gonna be recessing and then we're gonna have a jury up here for whoever wants their jury trial. Hi, we have the babies here today. Yay! Let me see the baby. Bashan, it's your favorite. It's Coco.
How are you doing?
Good
All right.
morning.
Oh, you. Oh, Coco, hi, Coco, baby girl.
Oh, you did? Did you enjoy your birthday?
Of course she did.
Bashan, it was her birthday the other day. I saw the photos.
I know, she had a whole photo shoot.
Oh, and she's over here doing yoga poses.
Do you want to see if we go or not?
Martinez? That's Martinez. Okay, so the jury will be in thank you so much. Norma, can you call a jury for 11:30?
You want her?
Yes.
You wonder, you need to relax. All the crazy.
Yes.
How are you? Yeah. How long was your training? It took about 4 years. I mean, I know we get late, but. Good morning. But my cousin's not.
All right, could I see the violations reports on Velasquez, Gonzalez, and Riojas?
6 days, 6 hours a day.
Jesus, Eric, Alexander, Velasquez, Pearl Gonzalez, Christy Riojas, she is bringing joy to the courthouse. All right, state,
Yes.
for the victim impact on Jacob Kawazawi, are they present? And you all are ready?
Yes, sure.
All right, so they'll bring your client out.
2 seconds with my client, just to.
Sure.
Have a low down.
Okay.
Thank you, Judge.
Hi, good morning. How's it going?
Good, all right. I understand there's a victim impact panel that's gonna be happening right now.
But no, it's just the victim impact. I think they have maybe 2 witnesses. So that shouldn't take that long. And then there's a second victim impact statement with another defendant, and that shouldn't take that long. If your client is here, just ask the deputies to have him brought out.
I have family here, so I'm gonna, can I take like 30 minutes with them?
No problem.
Thank
Just let us know whenever you're ready. You're welcome. Adriana,
Adriana.
yes. The last name is Adriana. I'm sorry, no, that's the first name. Yes.
Yeah.
And then Deputy Laura Scott's client, but I know you have to do them separate. All right, Mr. DeWalt, are you ready?
I am your, we got it.
All right, so Deputy Lord, do you want him to remain in the box or here?
Are we on that side? Yes.
All right, Mr. Kawazawi. So you have persons here who want to address you. I require that everyone treats everyone with respect, so just listen to them, internalize what's being said. Do you understand? To everyone who's going to be speaking, there's not to be any outbursts by anyone. Otherwise, you will not be allowed to continue to speak. Does everyone understand? All right, so you may proceed. All right, just give me a moment. Don't print anything during victim impact. All right, you may proceed.
Losing our son has been my hardest goodbye. I relive the moment I received that phone call every night. My mind doesn't want to face reality. He is no longer with us. I look at all his pictures and think of all those precious moments we had with him and realize no more memories will be made. I then realized I would never see no more skate videos, which was his passion. I will no longer hear his voice, his laughter. I will never see him smile. Throughout my son's 20 years on earth, we have never been separated. Not one day went by we didn't talk or text. I feel so lost without him. My son Johnny was truly a miracle from God. We struggle a lot with him health-wise, and we had overcome all odds as a premature baby. Sometimes this pain is so unbearable, I can't even get out of bed. It has been a struggle for me to go on. It has me questioning my faith. Why him? My boys were my world. They were my reason for getting up every day. They were my inspiration for life, my greatest accomplishment. I feel so defeated. A week before my son was taken away, he texted me this point. Somewhere between then and now, it went from mom, stop telling me what to do, to mom, please tell me what to do. Somewhere between then and now, it went from mom, you don't understand, to mom, I don't understand. Somewhere between then and now, it went from mom, stop asking me so many questions, to mom, I have so many questions. Somewhere between then and now, it went from mom, leave me alone, to mom, never leave my side. Somewhere between then and now, I realized the other half of my heart was always the person who created it in the first place. It killed me inside. I had to sign my son's death certificate on his 21st birthday. Change keeps me going, but for me, my life fell apart the day my son's heart stopped. More from the fall. I'm sure the court has many speeches on how great someone's son, daughter, father, mother, loved one was. But my son lived and died above it all. My son was a caring person, so caring. Animals loved him a very sort, and he loved them back as just as much. As a baby, he was born 10 weeks early at 2.5 pounds, but yet didn't struggle or have complications. In his early years, he would practice skateboarding in my basement endlessly. Despite his asthma, not to win competition for himself or for his team, and he won many first place competitions. His final Christmas in 2022, he came home to visit. We call it the best Christmas ever. My mother, his grandmother, started crying as gifts were being opened because they had no money for gifts either. He was the first to reach for her and hugged her and said, "Family is more better than any gift." He died this way as he tried to please friends, and he picked up a pregnant girlfriend, not his child, and tried to support her financially while struggling on his own. This is the person he was killed as. Emptied inside, struggling to be motivated has life been since then. Empty chair at every Christmas, now just a decoration on our wall. And today we watch justice, fellas in sentencing these animals. I pray God's for them as the halls darken around them in prison and the rest of our lives. Thank you.
Thank you. All right. And then the parties here for Angus Ockles Talbot.
Yes, Your Honor, I'm here for you.
All right, they're gonna bring him out and then we'll take that up.
Thank you.
Welcome. Yes, settle.
Oh, settle, I'm sorry.
Yes, she's here.
Getting confused. So purples are gone by cells, brother, guy. High school was awesome. She's.
But before we do that, let me do the second victim impact.
We're still missing her.
Okay. Pearl Gonzalez. Christy Riojas. Jesus Alexander Velasquez. I guess that should be junior instead of ER.
Right.
All right, Norma, if you can call their attorneys. All right, thank you. And one is with the public defender. Okay.
We're ready, Judge.
All right. Mr. Oakles Talbot, if you'll stand over here, please. All right, Mr. Oakles Talbot, I require that everyone treat everyone with respect. So family members have some words to say to you. Just listen to the words and internalize it. All right, you may proceed.
I'm sure the court has heard many speeches on how great someone's son, daughter, father, mother, loved one was, but my son lived and died above it all. My son was a caring person, so caring, animals loved him of every sort, and he loved them back as much. As a baby, he was born 10 weeks early at 2.5 pounds, but yet didn't struggle or have complications. In his early years, he would practice skateboarding in my basement endlessly. Despite his asthma, not to win competition for himself, but for his team. And he has won many first place competitions. His final Christmas in 2022, he came home to visit. We called it the best Christmas ever. My mother, his grandmother, started crying as gifts were being opened because they had no money for gifts that year. He was the first to reach for her and hugged her and said, "Family is more better than any gift." He died this way as he tried to please his friends and picked up a pregnant girlfriend of not his child and tried to support her financially while struggling on his own. This is the person he was killed as. Empty inside, struggling to be motivated, has life been since then. Empty chair at every Christmas, now just a decoration on our wall. And today we watch justice fail us in sentencing these animals. I pray God for them as the halls darken around them in prison and the rest of their lives. This one's from his mom. Losing our son has been my hardest goodbye. I relive the moment I received that phone call every night. My mind doesn't want to face reality. He is no longer with us. I look at all his pictures and think of those precious moments we had with him and realize no more memories will be made. I then realized I will never see no more skate videos, which was his passion. I will no longer hear his voice, his laughter. I will never see him smile. Throughout my son's 20 years on this earth, we have never been separated. Not one day went by we didn't talk or text. I feel so lost without him. My son Johnny was truly a miracle from God. We struggled a lot with him health-wise, and he had overcome all odds as a premature baby. Sometimes his pain is so unbearable, I can't even get out of bed. It has been a struggle for me to go on. It has me questioning my faith, why him? My boys were my world. They were my reason for getting up every day. They were my inspiration for life, my greatest accomplishment. I feel so defeated. A week before my son was taken away, he texted me this point. Somewhere between then and now, it went from "Mom, stop telling me what to do," to "Mom, please tell me what to do." Somewhere between then and now, it went from "Mom, you don't understand," to "Mom, I don't understand." Somewhere between then and now, it went from "Mom, stop asking me so many questions," to "Mom, I have so many questions." Somewhere between then and now, it went from "Mom, leave me alone," to "Mom, never leave my side." Somewhere between then and now, I realized the other half of my heart was always the person who created it in the first place. It killed me inside. I had to sign my son's death certificate on his 21st birthday. Time keeps me going, but for me, my life fell apart the day my son's heart stopped. Thank you.
Thank you. Do I see the file on Corbin Samansky?
Present.
Morning, Judge. I'm present on that case.
Right, good morning.
How are you, Judge?
Oh, I'm doing great. Have you conferred with the state?
I have, Judge. They were going to look at their file and then we were going to discuss the case further. The only thing that I believe that I may be missing is some cell phone video that's referenced in some of the reports, but I can confer with the DA on that.
All right, state, do you have cell phone videos on Corbin Levi Samansky? He's on page 3.
Judge, you not know.
All right,
Check though.
okay. All right. Ms. Ferguson, set this for discovery and state this will be set for discovery in 30 days.
Yes.
And counsel, at that 30-day time period, if you have not conferred with the state before that time period, you'll need to be in court.
Sure, Judge. I apologize if I was supposed to be there this morning. I talked to
No. You can appear by Zoom, but I want to make sure that there's communication between the defense and the state.
Yes, Judge. Absolutely.
All right, Ms. Ferguson, what date? All right, so we're going to come back on August 28th for discovery. Mr. Saminsky, I know that you are at work, so you can appear by Zoom.
Judge, I've got a conflict. I'm going to be in Tennessee on the 28th. Is there any way to do that earlier that week?
What are you doing in Tennessee?
Judge, I'm on vacation starting the 28th, the morning of the 28th. I leave on an airplane to Tennessee to go play golf.
See, people, people tell us these things and then, I don't know, we're sort of jealous.
I know, Judge, I apologize. I didn't want to say it, but you asked me.
All right, Norma, if you can, when do you leave?
I leave on the morning of the 28th, so I could do it the day before, which is the 27th.
All right. Norma, can you put this then on the, well, aren't you going to be packing on the 27th still?
Judge, not really. I just got to throw my golf clubs and some shorts in a bag.
Okay. All right. We'll put it on the 27th. Norma, is the 27th a good day or no? All right. So let's do it the 26th then. Is that a good day?
Yes, Judge.
All right. We can do it for the 26th. Wednesdays are usually when we're in trial.
Okay, perfect. I'll see you guys on the 26th and I'll reach out to the state.
No, he's still here. All right, so it'll be the August 26th council.
Thank you, Judge, very much. May I be excused?
Yes, you both may be excused.
Thanks, Judge.
Thank you. All right, thank you. My Odyssey just went down, so.
Okay.
Yeah. In the bottom of this chat. Yeah. Yeah. You're on salary. This is.
State and on, settle, I'm sorry, thank you.
Oh, us?
Yes,
Yes, Judge.
hello, Hunter.
Hello, Judge.
Hi, so what is happening with these other cases?
Which other cases, Judge?
On Campion, I have a 2025 CR 007085 and some PF cases.
Or
Oh, do you know what? You all are not on Valerie Campion. You're on Settle. I'm sorry.
I'm on that one, Judge.
All right, just give us a moment, counsel.
I was like, oh, shoot, I don't remember those, Judge.
I was like, I don't remember those
I can
either.
update you, Judge.
Okay. I was like, what is happening with all these cases? All right, if Ms. Settle will come forward. Yes. Okay. Is this? Yeah, I don't know why. I'm doing the best I can with that. Is that better or not better? No, it's just me speaking louder. I don't know why this doesn't work. It's working. I can see it. It's in my testing. Yeah. All right, so is this good? All right. I'm trying. It's still, is that loud enough or no? Okay. All right, court is calling 2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed, is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication assisted treatment. There was nothing else, no other substances.
All right, so the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case, and when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also, I had some argument for the court too, the court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced, but I verified with felony drug court that should she be placed on probation, they're able to accept her and can squeeze her in next.
All right, so state,
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're gonna see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI back in 2020, they would go for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS, she's been compliant, she's been enrolling programs, she's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off, she's not fled, she's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Ms. Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for very structured supervision, because I do believe that it is a necessity in Ms. Settle's life at this point. I believe drug court would be appropriate, and if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, Your Honor?
All right, so normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Okay.
All right.
Judge, on the second degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's, the state is opposed, but there is an application for deferred on that case.
So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession, the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you would be subject to the full range of punishment if you were revoked. Do you understand?
Yes.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settle's, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. Yes.
The case ending in 240, are we proceeding on count 1 or 2?
Let me see. They're proceeding.
Okay.
They're proceeding on count 2 as a repeater. I'm sorry, wait a minute. They're proceeding on count 1. They're waiving count 2 in the repeater.
Judge,
Yes.
here's that docket back and we initialed the plea bargain change.
All right, thank you, Hunter. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 0000240. The court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is to run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're going to come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
Just one moment. Deputy Laura, are you okay? Thank you. All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please? No contact, did you say no harmful or injurious?
No harmful or injurious contact with KPEC, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fine in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing in that cause number, counsel?
Nothing from the state judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled trial court certification of defendant's rights to appeal. In that cause number, did you review it with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. 200 hours of community service restitution. The court will show that 100 hours is satisfied upon the completion of parenting classes. GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240 and referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
It's on the other call number as well. Bill visits.
Oh, thank you so much. Field visits 1 time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession.
Yes, sir.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No question.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You say you have a new child. Your counsel has told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself 2 questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you, Judge.
Thank you. It's always great seeing both of you guys.
Me too, Judge.
All right. Thank you. So Hunter, how's it been going?
Been good, Judge.
Yeah,
Okay.
I'm loving the bow tie.
Thank you. I wore purple for moms.
Oh, mom appreciates that.
I'm about to start school again.
Oh.
Starting public school this year, so the oldest.
Oh my gosh, how old?
6.
My niece is about to start school. She's 3. And I'm like, my baby.
Yeah.
But-
Really fast, Judge.
Yeah, it is. And they're gonna enjoy it. I'm gonna pray that they have a great year.
Thank you.
All right.
Let 'em know.
Okay.
Come on and say hi.
All right. Have a good one. And Mr. Brooks? Okay. All right, Ms. Abrams, if you'll let Ms. Settle know that felony drug court is going to supervise her. Thank you.
Okay. I know where it's. Please just give me that. Right. Is that always the little thing?
Chase Lopez. Hello.
Morning, Your Honor.
Good morning. All right. All right. Mr. Lopez, today is your plea deadline date?
Yes, Your Honor. I'm covering for Ms. Knowles this morning. When I conferred with Mr. Garahan, there's still some discovery outstanding. And they're asking the court to reset the plea deadline one time to allow the state to provide us that discovery.
Okay, what discovery is missing?
It's, Judge, it is actually missing. I looked on Veripic and they don't have the body cams on there, and that's what's missing.
Okay,
And I was unaware, the offer had been extended. I just was unaware until presently that I believe Caitlin Knowles was the main attorney on this. And I was just notified today that she had notified Mr. Solansky that.
all right, so when do you believe you'll have that?
2 weeks to 4 weeks, Judge. I mean, Megan Galloway has just emailed BCSO to obtain that.
All right, Ms. Ferguson. If you'll extend this plea deadline date for 30 days, there'll be no further extensions.
Thank you, Your Honor.
All
Thank
right,
you,
thank
Judge.
you. What date? All right, August 21st. Thank you for addressing appropriately for court. Once you sign the reset form, you're excused, okay? Thank you. Thank
Have an
you.
excuse.
Yes. All right, who's here on Adriana Ramos? Hello. All right, have you had a chance to meet with your attorney? All right, and defense?
Yes, Judge, I've met with my client, just assigned today. I need time to go through discovery. And so I asked that we're shooting you a court date.
All right, Ms. Ferguson, on this, do 30 days for discovery and counsel. There's going to be a quick turnaround after the discovery. All right, August 21st, counsel.
That works, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome. David Moses Escobedo. David Moses Escobedo. Thank you. All right, the bond was reinstated. Why is he still in custody?
It is not showing that it's been reinstated, Judge. I looked online yesterday. I spoke with the bondsman. They said that they had agreed to it. I didn't see them file anything.
Yeah, I've signed everything. It is 2025 CR 02743.
Odyssey didn't show any updates in regards to that.
Okay, because he should have been released.
Mm-hmm. 2743.
Because bond was supposed to be in front.
No, the bondsman sent something over. All right, you want to get in touch with the bondsman?
Okay,
All right.
they need to file something.
But they did file something. I remember asking that the bond be restored.
With that.
So if you can have them, Mr. Escobedo, just have a seat. If you can see if they can find it. Yeah. Michelle Battles. If you'll come forward, please. Hello. Hi, your attorney is currently on vacation. Ms. Ferguson, if you'll recall this back for August 26th. All right, so once you sign the reset form, you're excused. You're welcome. Valerie Campion.
Good morning, good.
Good morning. Hello.
Hi.
Hi, so you were late for court. Here's the thing. You cannot be late for court. You've been here before, you know where the court is located. Other judges, guess what they would have done? Taking you into custody. Once you're late, you're late. You understand?
Yes, ma'am.
Court starts at 9 a.m. All right, state. Has an offer been tendered?
Judge, an offer was tendered on the cases that are indicted currently. She, as the court can see, she's got a number of pre-filed cases. The state checked this morning, there's no labs on those cases, so we would be asking the court to see if they would give us a little bit more time so we can try to encompass all of those cases. But just to answer the court's question, an offer was tendered on these specific cases, yes, but there's no agreement on these specific cases yet.
All right, Ms. Ferguson, on this case, I need a plea deadline date with the jury trial setting. It should be a short trial.
Yes, any of these would be short, Judge.
Okay. All right, your jury trial date and plea deadline date is going to be September 23rd. The court will not consider any plea bargain agreements after that date without good cause. Otherwise, you'll have to plea open to the court. Do you understand? You need to make sure you're on time.
Yes.
All right, once you sign the reset form, you're excused, and thank you for dressing appropriately for court.
Thank you.
You're welcome. And Matt, on those cases, if you can get an acknowledgement of discovery from the state, if you could do an acknowledgement of discovery, if that hasn't been previously done on those cases.
Okay.
All right, thank you. Pearl Gonzalez. All right, are you ready?
Yes, Your Honor.
And is she here?
That's my knowledge.
All right. Deputy Laura, if an announcement could be made for Pearl Gonzalez. All right, she has a PR bond, counsel. The court is in receipt of a violation report.
That's my understanding, Judge. And I know that this honorable court set this compliance hearing today. My fear is that she did not get notice of that. I was not able to relay that to her. So we're just requesting that the original date in August be left in that. I don't know if she was actually noticed to be today.
Right, well, so here's the court's issue. With the violation reports, of course, the court doesn't have to set a hearing. But according to the violation report, it states that the defendant failed to report to our office as directed by the court. And then on July 17th, the defendant completed their orientation and left, refusing to provide a UA sample to our office. And they've been seeking to bring her back into compliance, but have been unsuccessful.
That's my understanding, just as of the issuance of that. I don't know if that has changed from now until this point. So if she got back into compliance with them and not been updated. So that's where I'm at, Judge. I just don't know where we're at currently.
Well, if there's no objection from either side, I can email the pretrial services officer and ask if she is in compliance or not.
No objection from the bench.
No objection. All right, so just give me a moment. Thank you. All right, who's here with the interpreter? Are you all ready? And who's your client, sir?
Angel Suspedes Ramos.
All right, have you asked for the file to be pulled on that one? Angel Cepedes. No, I don't have it. All right, so first things first, it's on page 2. First things first, Why were you late for court? Court starts at 9 a.m.
You like that one, book? I was in court, pero no, but I didn't give my name, but I was here.
No, I call the docket at 9. And when people answer the docket, then I check them off as having appeared. But you're scheduled for jury trial today.
That's correct, Judge. We filed a motion for continuance on this.
All right, as soon as I get the file, we'll see about your motion for continuance. Okay. Okay. All right, the court is calling 2025 CR 002-807 State versus Angel Cepedes Rhonda. Can I have parties announce?
Ashley Jones for the state.
John Reitmeyer for the defense.
All right, and are you Angel Rhonda?
Yes.
All right, we have an interpreter. If the interpreter could raise your right hand, do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right. Defense, you filed a motion for continuance.
We did, Your Honor. In getting ready for trial, we've subpoenaed several records that we haven't been able to receive yet. One of them, we were told the staff is not back from summer vacation. The other one, they have paused our request and sent it to the Attorney General's office for review for open records. We've had issues getting witnesses that could help the defense due to several fears that they may have about coming forward. With that said, we did receive a late disclosure from the state about 404B evidence that I haven't had time to go through. There's also been another late upload to e-discovery that I was able to look at. I have talked with the state. I don't fault them for the late disclosure, but.
Well, no, here's the question, because this has been set for jury trial since May. This has been on the court's docket since April. So what was uploaded late?
It was about the complaining witness in a meeting that they had. There was a name that was mentioned in this interview with her that we have not seen before, who may have information.
And when did this interview with the complaining witness take place?
Your Honor, we met with the complaining witness last Tuesday. It was quite a very long interview with an interpreter with Mr. Caesar here. And that's when we received the information and we uploaded it over the weekend. And
this is what I don't understand, and maybe somebody can help me understand. I don't understand how a case is indicted and then the state is speaking to the complainant, a day before trial or a week before trial, and all of a sudden there's new discovery. Like, why is everybody waiting till the last minute to speak to a complainant? All ducks should be aligned and in a row. Maybe I did things differently when I was a prosecutor, but once I had and took a case to indictment to a grand jury, I received all the information, done all the investigative work. And if I met with a witness, I would tell them, this is the day we're going to trial. What you need to do is listen to the questions, answer the questions, and tell the truth. That was the extent of our meeting. I don't understand waiting and then interviewing a witness, then obtaining all this new information, then dropping it on the defense. And we're scheduled for trial. I don't understand.
Judge, in addition to my own reasons, I understand the state has a reason for themselves.
yes, Your Honor, I can speak to that. We do have an officer who is out of town starting tomorrow. As the court may or may not know, there was a translator needed for the investigation that was done. We were able to get a hold of that officer, and he is out of town and starting tomorrow.
All right. So as far as the state not having its witness, the state is not, the court is not going to grant a continuance based upon the state not having their witnesses. That witness, everybody knew this was the jury trial date because everybody was here when we said it. So, and then with the 404B,
Well, it was late notice. I haven't had a chance to go through that, Judge. I just saw I just got notice of the filing yesterday.
well, has the law changed with 404B notice that can be given up until the day of trial? What's in the 404B?
And Your Honor, I can speak to that. It's actually stuff under 3837(1)B, which is just nature of the relationship stuff. It was a couple instances that the complainant described that described the nature of the relationship throughout.
Well, that's not coming in. So what's the next issue?
But the-
Any 404B that is related to their relationship, that's not coming in.
Then Judge, it would just.
That
be-
was just dropped upon you.
It would just be my original, we had subpoenaed records for trial and we don't have them.
When were the records subpoenaed?
Offhand, several weeks ago. I don't have an exact date I'm talking about.
All right, so I need to know when the date the records were subpoenaed. Your other issue in your motion for continuance is that there are fears of immigration enforcement as it relates to your witness.
That's right.
Don't know what to do about that. There's gonna be fears, so I can't grant a motion for continuance based upon a person's fears of coming into court. Now, if somebody wants to agree to have the witnesses by Zoom, you can, but otherwise I'm not giving a motion for continuance because someone is afraid of immigration consequences. Because if that's the case, then we will not be able to have a trial, who knows when. All right, anything else?
Not from the state?
All right, motion for continuance is denied. And state any 404B information that has to do with this defendant's relationship to the client. That's not going to be admitted unless the defense wants it admitted.
We understood, Judge.
All right.
Is there a time you like us to come back to?
Yes, I'm gonna have the jury's gonna be out in the hallway by 11:30. I anticipate us recessing and doing jury selection at 1:30. All right, thank you. David Escobedo. Oh, I'm sorry, counsel. I'm sorry, Mr. Escobedo. Just have a seat. I'm waiting for your attorney to give the court information. This is 1:30. All right, are the parties still here on Pearl Gonzalez?
Yes, ma'am.
All right, so the email the court received from pretrial services that she is not in compliance. And what they sent me, they said, as of this writing, no, ma'am, she has failed to comply with pretrial. The defendant has not responded with us since 7/17 and multiple attempts have been made by her officer.
Thank you for the update, Judge.
Sure, no problem.
I know she's indigent. I believe it's a possibility of her being perhaps living on the streets. She was in custody more than 90 days without an indictment being generated, so that's what the PR bond it did issue. I guess if we could be heard on, I guess,
Sure.
state may want to be heard on.
All right, the court is calling 2025 CR 008-155 State versus Pearl Gonzalez. Can I have parties announce?
Jason Garahan for the state, Your Honor.
Renee Munoz on behalf of Ms. Gonzalez.
All right, this hearing was scheduled at 9 a.m. It is now 10:46 a.m. The court received a violation report that the defendant is out of compliance with pretrial services. According to the violation report, they state that she attended orientation and left, refusing to provide a UA sample to our office. For the record, both parties had no objections to the court emailing pretrial services to see if Ms. Gonzalez was back in compliance. And the email the court received is that the defendant is still out of compliance and has not been seen since July 17th, and they made multiple attempts to contact her. Defense, is there anything you wish to put on the record?
Yes, Judge. I know that she is indigent. She's being represented by the Public Defender's Office. And we believe there's a chance she may be homeless and otherwise unable to abide by the current conditions as set. We respectfully request that a summons issue in lieu of a warrant.
All right, state.
State request, judge's warrant, Your Honor.
All right, the court will issue a judge's warrant. Counsel, if your client makes an appearance, the court will reconsider. But for now, the court is issuing the judge's warrant and remanding your client without bond.
I understand. Thank you, Your Honor.
All right, thank you. David Edward Lopez. Is your attorney here?
Yes, Your Honor, I'm right here.
Okay, sure. Yes.
Yes, Your Honor. I've been conferring with the state. I received some CPS records today. I have not yet, but I need to request some records from Cedar Crest. It's an completion place. I probably need a court order to try to get those. I've been talking with the state. I have tendered the complainant's name and her mother's name so the DA can have a chance to speak with them. We're asking for a continuance in this case to put all these things together.
All right, has a motion for continuance been filed?
It hasn't. I thought the state was going to ask for this.
Apologize, Your Honor. Our understanding was that it was not set for trial, it was set for either discovery or a plea deadline hearing.
Yes. So it says, today is your final discovery. And you were filing an investigation motion?
I filed a motion for an investigator. He met with my clients. I did receive new discovery today. I picked up the disc. I'd like an opportunity to review it and go over that with my investigator. We have a meeting set with the investigator to see what other documents we might need to either subpoena or ask the court to get a court order for this.
All right, Ms. Ferguson. If I can have a plea deadline date and jury trial date, please. I'm sorry, when?
Number 23rd.
All right, your plea deadline date and jury trial date will be September 23rd.
Thank you, Your Honor.
All right, you're welcome. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. Thank you. Who is here on Yvonne Ordonas?
Present, Your Honor.
Hello. Court is calling 2025 CR 003-633 State versus Yvonne Ordonas. Can I have parties announced?
Megan Galloway for the state.
Renee Munoz on behalf of Ms. Ordonez.
And are you Ms. Ordonas?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there's no application. Ms. Ordonez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Ordonez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes,
Did you intend to give up those rights and enter into a plea in this case?
yes,
Counsel, has your client been able to provide you with any defenses?
She has,
Do you believe she has a rational as well as a factual understanding of the charges against her?
my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Ms. Ordonez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 days in the Bexar County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be the plea?
yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor, and I can speak to the term if you'd like at the appropriate time.
All right, thank you. Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, sir.
Did you sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, there is to be no contact with Freda Flores. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
yes, sir.
Then to the offenses charged, how do you plead?
Guilty.
State any evidence.
State offer states one in attachment.
No objection, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. State?
Your Honor, the reason that this agreement was struck or offered by the state and accepted by the defense was because the offense date and for the offense that we're here for is February 13th of 2023. The defendant did have some additional felony charges for which she was indicted for in 2024. However, this case had not been turned into our office yet. And so regarding the 2024 indictment, she did take accountability and enter a plea on those cases. However, this case was still outstanding at the time. In that case, she had 255 days worth of credit in the Bexar County Jail that had this case been filed at the time, she would have received credit for. And so I took that into account, and that's why we reached the agreement that we did.
All right.
That's correct, Judge.
All right, the court will follow your agreement, find you guilty, sentence you to $800 time and money to run concurrent. 2 days in the Bexar County Jail on 1244. There's to be no contact with Freda Flores. The court will give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing, I understand people get upset with the way people are driving. And it appears from reading the police report, both of you were in the wrong. She was in the wrong for riding your bumper, almost hitting you. She was in the wrong for throwing, some sort of liquid at your vehicle. You were in the wrong and in a dangerous situation from getting out of your vehicle and striking her vehicle. You understand?
Yes, sir.
All of this could have been gone left, well, farther left so quickly, because if she would have had a gun, she would have ended up shooting you. And then everybody would say, well, was it justified? Was it not justified? Because she came at her vehicle with a weapon. You understand?
Yes, sir.
So what I've discovered is when you're driving, just have patience. Don't honk at anybody unless it's to say hello. And you know what my mom always told me? Let them pass. She's like, just let them pass. Your job is to get from point A to point B safely. You understand?
Yes.
All right, good luck to you. Have a great day.
Appreciate it.
You're welcome. Vincent Arredondo.
We're here. I'm actually waiting on some documentation to be emailed from my office to the prosecutors. I was gonna ask the court to reinstate a bond. He was in the hospital apparently in the last court setting. But it should be here in a second.
All right, thank you.
Thank you.
Oh, with regards to reinstating bond, you'll need to reach out to the bondsman and see if they have any objection.
Well, not even reinstating it, if you would set a new bond,
Okay.
his family can make it apparent.
Okay, sure.
Thank you.
Oh, the clock is correct. Who knew? All right, everyone, I'm going to take a 5-minute break. Just give me a moment. Yes. There are some good ones. Cindy, I have a
You're
couple.
so bad. Okay. I do like yours better.
Cindy, the honey.
I like those better. Oh. They go down better. Yeah, they do, right?
It's sort of like Mary Poppins, a spoonful of sugar. I'm sorry. Yes.
We have arguments set for today, and we're wondering, should we come back at 1:30? Do we have a lot? And by we, I mean,
All right, if you're all ready, we'll take it up.
we're ready.
All right, sure. All right. Could you pull this file, please? It's just 1 second. I just got stuck by a stapler. Oh, no, you guys be careful because it's sticking up on the folder. But I cleaned my hand. It's this one, Moses, so watch out for Moses. Yes.
If I may run to the restroom.
Okay, sure. The attorney's name is Butler. Yes. Oh, I have a file, I'm sorry. On that one, yes, I didn't return it yesterday because I knew we were gonna. All right, is there an attorney here for Christy Riojas? Attorney here for Jesus Enrique Alexander Velasquez Jr.? Attorney here for Vincent Arredondo?
Yes, Judge, I'm here. We're waiting on we're still waiting on the email to come in.
All right, just let me know when you have that and I'll take it up.
I will.
Okay. Jacob Vicuna. All right, if you'll come forward, please. Oh, where's your client?
Oh, she's not here.
All right. Let me. All right, the court is calling 2025 CR 0075548 State versus Jacob Vicuna. Can I have parties announced for the record for the state?
Deputy Collector of the State of Texas, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 11 a.m. The defendant has not made an appearance. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. He is not out there.
Defense, have you had any contact with your client?
No.
All right, state, it appears that he is on a PR bond. Any requests
For a judge's warrant, Your Honor.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider. Thank you. Thank you, State.
Thank you, Judge.
All right, are you all ready on Ronald Allen?
The state is ready, Your Honor. Court President, Judge, ready.
All right, if parties will come forward. Hello, Mr. Allen.
Hello.
Not here yet.
Just give me one moment. All right, if everyone can please whisper, we're going to go on the record. Court is calling 2025 CR 007563, State versus Ronald Allen. Could I have parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Charles Butcher for the case.
All right, and are you Mr. Allen?
Yes, I am.
We were here yesterday. The court heard evidence on defense's motions. The court ordered or requested that both parties be present today to make their arguments. And so defense, it is your motion. So, and both parties agreed for the hearing that they would combine the motion to suppress and the motion to dismiss. The court requested if both parties would agree to combine the motion to dismiss and the motion to suppress due to objections that both parties were having to particular evidence. And some of the objections with regards to the motion to suppress were not appropriate for a motion to suppress, but they were appropriate in the motion to dismiss. So that is why both parties agreed to combine the two motions. So with regards to the motion to suppress, what I would like to start with is we'll start with number 2, where the defense's argument is there's no probable cause. You may address that, counsel.
Judge, regarding we did hear testimony from Mr. Allen, Officer Che, and Attorney Ireland. We heard Attorney Ireland's recording. We'd seen the state's theory take its full shape. The reason we think that this lacks there's a lack of criminal conduct on this matter, because from the outset, the prosecution relied on a paraphrase quote allegedly said by Mr. Allen, which was, "If I don't get custody, I will make history and there will be dead bodies everywhere." But when we heard the recording, that phrase was never heard by the court in the recording submitted by Mr. Ireland and played for the court. The actual statement made by Ronald was, quote, "So if I was gonna do that and I knew all this stuff was gonna happen, period, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro." Later, he says, because if they don't get busted, there's going to be dead bodies everywhere. Now, our contention is that neither of these statements includes an assertion of personal action on the part of Mr. Allen. There is no named victim. There is no identified target. And there is no expressed intent to carry out any kind of violence. It's also troubling that the DA's office or Detective Che did not fully review the audio, but simply adopted Mr. Ireland's paraphrase as fact. I think that this misstep undermines the reliability of the charging process and bolsters the necessity for judicial correction through either suppression or the dismissal.
All right, and with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat that there will be bodies?
Well, I think a part of this is the nature of the charge, is that this is a terroristic threat on a public servant. Although other public servants are discussed in the 12-minute recording that we heard, none of those public servants are specifically targeted in any of the statements that Mr. Allen made. They're talking generally about a number of things related to the legal strategy, related to the tactics that are being used. And basically, my client is speaking freely to his own lawyer.
All right, but I'm reading the indictment. Is there any objection to the court reviewing the indictment?
None from the state, Your Honor.
None here.
All right, so I'm reading the indictment, and the indictment reads that on or about April 21st, your client did threaten to commit an offense involving violence to a person, namely, and then it says to kill people with intent to place the public or a substantial group of the public in fear of serious bodily injury. So according to the indictment, it's saying a group of people and not necessarily a person who's a public servant.
Of course, Judge, we do recognize that that's what the indictment says. We accept that that's the indictment generally, but we do have issue with the idea that this statement has been taken out of context. He's not particularly naming that he's going to do anything to the court or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years and I work in this courthouse every day. And I don't feel like Mr. Allen is a threat to this court either. Further, when we talk about this, Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. He was not emotionally stable at that point because of the difficulty that he was having with his custody matter. So he was also shocked to learn that the words that he mentioned in his own lawyer, where he has an expectation of privacy, were being recorded and being used against him to third parties.
All right, so do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with
Exceptions, yes. All right, so do both parties stipulate?
The state stipulates.
All right, so then the next question I have of both parties, is there an exception? And I think both parties know the answer to the confidentiality if there is a threat of violence or if there is a threat of a future crime.
Yes, the state is aware.
All right, and defense, do you stipulate to that?
Yes, Judge, we do know that there are rules, Rule 105C7 of the ethics rule provide for permissive disclosure to prevent criminal acts. And we anticipate that Ireland would be arguing that he had discretion under this section if he reasonably believed the disclosure was necessary to prevent a future crime. However, according to those rules, the comments inside of those rules, comment 13 to 14 in the rules that are promulgated by the state, the magnitude, proximity, and likelihood of harm must be weighed. The threat must appear imminent and grave, and the disclosure must be no greater than necessary. The problem here is that Ireland disclosed everything and voluntarily handed over a recording, and that recording was not narrowly tailored as a warning. And then we have his own testimony where Mr. Ireland gets on the stand and he tells us, also in the recording, I'm not afraid of anything regarding this case. That contradicts a reasonable belief of a grave and imminent harm.
But counsel, wasn't his saying he's not afraid of anything about the case in reference to the pending civil case, not the alleged actions that we're here for today? I thought that's what he testified to.
Well, and I do know that what we're really talking about is that Mr. The lawyer that testified, that was this man's lawyer. He continues to try to expand and express that he's in deeper fear than he was in the moment. And I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately called the amicus attorney. He thinks he doesn't remember that, but we believe that he called the amicus attorney because we got a bill for that. And then further, he calls the Texas Bar Hotline, which is going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
All right, so let's start here. The first thing is that the court finds through stipulation, and I think both parties know, that when someone is speaking to their attorney about legal matters that they've been contracted to do, that normally it's privileged. But I think both parties have also stipulated that there are exceptions to that privilege. And one of them is if there is a threat of future criminal activity, or if there's a threat of harm to anyone else. So let's start. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense, whether or not that was privileged?
Yes, Your Honor, that was not privileged communication. It is detailed in the exception for furtherance of criminal activity, express or implied intent by saying if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies, implied, maybe the how. But this was not privileged communications between an attorney and a client. And no, the shift of the communication that you heard, the audio recording, that statement comes at like minute 10:45. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. So to say that the attorney, Mr. Ireland, wasn't scared, that was at minute 4. And Your Honor was correct in assessing that that was not related to the future threat that was going to come 10 minutes later, 6 minutes later. That is not privileged communication. Those privileges are to ensure fair trial, trust between parties. The privilege is not intended to grant people a right to threaten and to use words to cause a reaction like what happened in this case. It's not privileged.
All right, so the court is going to find that there has not been a violation of the attorney-client privilege under the disciplinary code 1.05C7. The court is finding that the recording is not illegal, as Texas is a one-party consent state, and the attorney knew that he was recording and he was a part of the communication. There was no third party in the room. It was Mr. Allen and his attorney. Now, with regards to the warrant requirement, both parties stipulated that this was that the defendant was arrested under warrant. So there's a warrant requirement that has been met with regards to that. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of your motion as well, client, Mr. Butcher.
Yes, Judge, that goes towards the motion to dismiss regarding this. I think there's some particulars in the recording and in what was discussed with Mr. Ireland on the stand. There are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. First off, Mr. Ireland said, you can fire me if you want. If you think I'm not doing my job, then go ahead. I think the implication from that is that Mr. Ireland had a calm and professional demeanor and he was not in fear. Further, Mr. Ireland said, you're getting F'd. In that regard, he's aligning himself with the client emotionally and tactically. And I think that matters because he's continuing to engage in this as not somebody that's looking for a criminal intent, but he's looking for a way to align himself with his client and think about the custody case strategically and tactically. He even says, I agree with you, when Mr. Allen indicates that he is concerned and afraid because of some coincidences that were happening in that litigation. Further, they even talk about subpoenaing a gentleman named Sherwood. So Mr. Ireland is strategically engaging regarding the subpoenas that he's going to issue and the work that he's going to do in furtherance of that custody case. Now, I realize that this court isn't about reviewing a custody case in any way, but what we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen testified that he believed he was speaking confidentially with his lawyer. He had no intent to harm anyone. He was emotionally distraught, particularly due to the custody losses, and he was shocked to learn that his words had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, I'm scared for my life, dude. That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases that are constitutional cases, and one of them is the Watts case. In the Watts case, in a 1966 anti-draft rally in Washington, D.C., an 18-year-old draft dodger made the following remark, quote, if they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ. This, by the Supreme Court, was interpreted as a threat. This was interpreted as a threat by the authorities under the United States Code regarding terrorist threats towards the president. But the Supreme Court found in 1966 that they reversed the conviction, holding that Watts' statement was political rhetoric and not a true threat, and therefore was protected speech under the First Amendment. Now, this applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to inflict harm. So hyperbole, exaggeration, or emotional venting, even if it's crude or alarming, doesn't qualify as a true threat. Lower courts later differed on the objective versus subjective standard on this, but Watts did emphasize the importance of both context and intent. In reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric that Mr. Allen was engaged in. Similarly, this case, in Ronald's case, it was emotionally charged, but it was conditional, and it was made during a private dispute involving custody. Now, Texas courts regularly apply the Watts principles. There's another case called Lopez v. State, where 631 Southwest 3D 107. In that case, the court explicitly cites the Watts case in evaluating whether a defendant's statements were true threats or protected speech. And in that case, it was held that the defendant's statements about bombing a school were not protected speech because they were specifically targeted and intended to be taken seriously. But the key takeaway on that is that Texas courts always adopt the contextual approach from Watts, looking at the surrounding circumstances, the intent, and the audience. In this case, those factors are highly in favor of a dismissal for my client. Further, there's another case called State v. Hansen, where the courts recognize that political hyperbole, even if it's violent in tone, may be protected under Watts. There's also the Dorset v. State case, where a defendant told officers, y'all better wear your vest because I'm going to start shooting. This was held as a true threat, but only because of the content, including a history of violence and the ongoing criminal conduct resulting in the officers responding in that case. Watts influences Texas law even without being codified. Texas courts do adopt some options of Watts because they talk about a true threat test as a conditional limitation in applying the criminal code 22.07. The judges are to act as gatekeepers even if the conduct appears to violate the literal text of the statute, but it must pass the Watts standard in these matters. There's another case, more recent in 2015, the Alanis v. United States case, where Judge the Supreme Court held that punishing threats require proof of a mens rea or a subjective intent to threaten. The person cannot be convicted. The Alanis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend for those words to instill fear or communicate a threat. In this case, the full transcript demonstrates Ronald's alleged threat was embedded in an extended stream of anxious, erratic speculation and emotionally charged grievances, where at one point Ronald even says, "I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen." He further elaborates, "Hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls." When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. So here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alanis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention, and the state hasn't shown that his intention was to make a threat to the general public.
At this juncture, isn't whatever your client's intent, that's something for a jury to decide? Or if this were a bench trial, then it would be for me to decide. But is that correct? That's something for the jury to decide what his intentions were. At this point, based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. It falls underneath the exception. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something for a jury to make that determination. At this point, this court, I'm just making rulings upon motions that are presented to me. But there are some things that I legally am not allowed to make rulings on. One of them is determining what your mens rea is, whether it was intentionally, knowingly, recklessly, whatever it may be. And that would be what is actually in the indictment. So in the indictment, they're stating that you made a threat with the intent to place the public or a substantial group of the public in fear of serious bodily injury. So at this point, for this hearing, it is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right? That would be something that a jury would decide. Now, if you were having a bench trial, then I would be in the place of the jury, and then I would listen to evidence and make a determination of whether or not I believe beyond a reasonable doubt that the state has met its burden based upon what's in the indictment. You understand?
Yes, ma'am.
So what I can tell both parties is that, one, there was a warrant. Both parties stipulated that a warrant was issued. Number two, the court is finding that while your communication with the attorney is confidential and private, right? But the exception to that, one of the exceptions, if there's a threat that's being made. So the communication, the court is finding the communication that you had with your attorney, the court is finding that that falls under the exception of attorney-client privilege. So, State, you want to address the defense's other points, please?
Yes, Your Honor, we would start with point number 5 in the motion to suppress, that the statement was not a true threat. The state is offering to the court and to defense what is Garcia versus State, 583 Southwest 3D 170.
Thank you.
All right, and I'm aware of the case, but I'll review it. Thank you.
I have flagged a couple important spots. The First Amendment does not protect speech like this. A true threat, and Your Honor, you will find this, I believe, on page 2, that first flagged one. True threats encompass those statements by which the speaker communicates an intent to commit an act of unlawful violence to a particular individual or group of individuals, regardless of whether the speaker actually intends to carry out the threat. And this Garcia case quotes a Supreme Court case, Black 538 US, and that's at 359. The reason that the First Amendment does not protect violent speech like this is to promote public safety and curb misdirection of resources. When defense brought up Watts, that is specific to the draft. And the gentleman in that case didn't know if he was or was not going to be drafted. So it was hypothetical, hyperbolic. In this case before the court, we heard the recording on Wednesday, 3 times, Wednesday, Wednesday, Wednesday. When the defendant talks about dead bodies everywhere happening on Wednesday, I'm gonna make history. This is not hypothetical. This is distinguishable from Watts. The defendant here is making direct threats. Now, this language is not ambiguous or exaggerated. If X, then Y. When defense says, well, look at the attorney, Mr. Ireland, he did not express fear. He did not interrupt or disengage. In the 12-minute conversation, it was 1 minute and 25 seconds after being threatened by the defendant that his attorney, his own attorney, says, get out of my office. Subsequent to that, this attorney paid for active shooter training for everyone at his office, paid for them to become familiar with guns, concealed carry, locked the doors to his office. The defendant scared this man, and that is the state's argument. This is not protected speech. It was intended to make a response. It does not matter if he intended to carry it out. The intent is to place the public in fear. It was directed to a specific date. We entered that Wednesday court date in the civil courthouse. It was, it was not a joke. It was not to be taken lightly. On that same case before the court, if we may go to page 3, defense spoke of lack of mens rea. Paranoia is not a criminal element. This conversation was more than exploring conspiracies against the defendant. This was not a private emotional procession or communication with the attorney. This is more than delusional, exaggerated, and distressed. It was a terroristic threat. He was not seeking knowledge. He wanted a reaction. Was it to light a fire? Who knows? But the fear was more than just at the office. It is at the courtroom. It involved the families involved in the civil proceeding. This type of language is not protected under the First Amendment. It is a true threat, and therefore defense's point number 5 should be denied as well.
All right, this is what the court is going to do. The motion to dismiss is denied. The motion to suppress is denied. I'm going to schedule this for a jury trial for September 30th. And so if there are more motions for the court to hear, please bring your motions before that date. Ms. Ferguson will make sure that it is placed on the docket.
Judge, is there any possibility that I can re-urge my motion to reduce bond
Yes.
at this time?
Well,
And
not
I'd
at
like
the-
to ask for that because
Well, not at this time, but if the state has no objection, we can do it later in the week.
The state would object.
All right. So you'll have to give them their 10-day notice. Or I'm sorry, state, how much time do you need? You need less than 10 days?
For the reduction,
Yes.
we would.
All right. So if you all will confer on a date with Ms. Ferguson.
Yes, Judge.
All right. And then we'll go from there, okay?
Okay.
All right. They may be able to do it sooner. Amanda Ellis. Yes.
For a reset.
All right. Where are you on discovery?
So the discovery, we got an offer today, the one to think about the offer.
I'm sorry. I'm sorry. You said you had an offer?
Yes, today, and when did you think?
Okay. All right. How old are you, Miss?
37.
All right, Ms. Ferguson, if you'll set this in 2 weeks for a plea deadline date, please. And it's Amanda Ellis. All right, August 14th, and you need to make sure you're on time for court. The next time a warrant will be issued. Do you understand?
Yes.
Unless there's good cause. All right, thank you. Once you sign the reset form, you're excused. You're welcome.
Your Honor, I finally got the email on the tried. I don't know.
All right. Just give me a moment, counsel.
Yes, ma'am.
Carlos Perez. Carlos Perez. They're gonna have to come back on another date. Just have a seat, sir. Matthew Stephen Martinez. All right. Fernando Guzman.
I'm here for him, Judge.
Yes. All right, counsel, where are we on discovery?
I believe that I have all this everything.
And was an offer tendered?
Yes, Judge.
All right, sir, how old are you?
45.
All right, Ms. Ferguson, I need a 2-week reset on Guzman for a plea deadline date. All right, it'll be for August 14th. What page is he on? All right, thank you. All right, Mr. Guzman, you need to be on time for court next time. Otherwise, a warrant will be issued unless there's a good cause for your being tardy. Do you understand? All right, and if you're drug tested today, what are the results going to be?
I've been taking medication for my surgery. He had bladder surgery, Judge, and that's a big part of why he's late.
Okay,
And part of why we need a reset, just get him a little more comfortable from the surgery.
okay.
And we expect that we might likely take that plea bargain.
All right, once you sign the reset form, you'll be excused, okay? Thank you.
One second, Roses Ross, that okay?
Oh, just give me 1 moment. I'm going through the line. Christy Riojas. David Moses Escobedo. All right, we're still waiting for your attorney. Oh, just let. Moses Ross.
Present ready, Judge.
Are you ready to proceed on the motion?
No, Judge, it's just a bond setting.
Ah,
Someone was working.
good morning. All right, is this,
It's family violence, but MTR, but the new number ones are criminal trial judge.
all
I
right,
believe that's, well, family violence gave it to us since it has the new number ones.
all right, the court is calling 2023 CR 3543 State versus Moses Ross. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Nick Aguilar for Moses Ross.
And are you Mr. Ross?
This one.
All right, you are here on a motion to revoke. It's a deferred adjudication, so you're entitled to a bond. Have both parties had a chance to confer on a bond amount?
Yes, Your
Yes,
Honor.
Your Honor.
And have parties reached an agreement as to a bond amount?
Yes, Your Honor.
And what would that be?
On each of the cases, Your Honor, a $15,000 bond.
All right, he has two cases.
Yes, Your Honor.
All right, and what are you requesting on each case?
On each case, $15,000, Your Honor.
All right, then the court is also causing 2024 CR 4456. All right, the court is aware of the defendant's history because he's on probation out of this court. So in each cause number, the court will set his bond at $15,000. There's going to be partial GPS, waive fees, and there's to be no contact with the complainant in each cause number. All right, Ms. Ferguson, I need a contested hearing on Mr. Ross. All right, so we're going to come back on August 18th for a contested hearing in each cause number. All right, thank you.
He would like to address you about the partial GPS.
I'm a full-time dad. I work all the time. And the reason why I'm in trouble right now is because, can I say that? I got caught with the.
Also, here's the thing. I don't think you want to speak to the allegations that are in the motion. So I'm telling you, partial GPS for employment. Thank you.
And then we signed a reset form.
Yes. All right, Vincent Arredondo.
Morning.
Good morning. How's it going?
Good, good.
I'm liking the tie color.
Thank you, thank you.
All right, so on this case, you're saying he was in the hospital, correct?
Judge, and the prosecutor's already taken a look at it. There's some emails that our client was sending that morning of court, I believe it was 18/24. And then there's also a document from Central Med where they said that dated that same day that he was under their care. He'd gotten a spider bite and was in tremendous pain. Your Honor, you were not here that day. It was Judge Angelini and Megan Enriquez, my associate, had asked him.
All right, everyone, please whisper.
If we could try to get the client in at a later date, later in the week or something, and that was denied. So what we're asking for is that you just set him a new bond with Judge. He's been in custody for about a month.
All right, and with regard, do you all have an agreement on the bond?
No.
No, we do not.
All right, court is calling 2024 CR 012424. And does he have a bond on the 2025 number or no?
Do you have a bond on your other case still, or is it just the remand on the one case?
I think it's on both of them.
Let me, just one moment, Cindy, off the record. Let me see if I can find if he has a bond in that.
Sorry about that, Judge.
No problem. All right, on this one, it shows that a bond was closed on this one as well. Let's see. Yes, so they did an affidavit to surrender surety on this one as well.
Oh, okay.
So on the 2025, it's the affidavit to surrender surety. And let me see if the other one is also an affidavit to surrender surety. Sorry, sometimes Odyssey is slow.
There's no problem, ma'am.
Okay. Okay, the only, let me see. All right, it says on here that on January 2nd, 2024, received a bond. Okay. Notice, setting. Ah, thank you. On this one, it shows a bond forfeiture. And then there's already a NISI. So that's on the 2024 case. All right. Now we know where we are. So on the 2025 case, that was a affidavit of surrender surety. And on the 2024 case, that was a bond forfeiture. All right, court is calling 2024 CR 012424 and 2025 CR 007553. State versus Vincent Arredondo. Can I have parties announced for the record?
Jason Garahan for the state, Your Honor.
John Coons for Mr. Arredondo. I'm here for Megan Enriquez.
All right, and are you Mr. Arredondo?
Yes, ma'am.
Do you have any objection to Mr. Coote standing in?
No, ma'am.
All right, so you're here requesting a bond, is that correct?
That's correct, Your Honor.
All right, state in each cause number, is there a bond amount that you are requesting?
The state would be requesting a $20,000 bond in each case.
20,000?
20,000, yes, Your Honor.
In defense, what are you requesting?
Your Honor, I request a $2,500 bond on each. These are state jail level offenses. We understand that one has been indicted as a repeater. And when you look at my client's criminal history, it's for the most part very low level offenses. There are no shootings or anything like that I saw. And, so
Any
we-
violent history?
Not particularly, Your Honor. However, he was in court in March of this year. And then this new case was, his arrest is in April of this year. So that's one of the positions of the state. Previous bond on each case was set at $10,000.
All right. Is there anything else?
No, Your Honor. Thank you.
All right, so Mr. Arredondo, can you raise your right hand for me, please?
ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Vincent Garza Arredondo.
All right, I'm going to set a bond amount for you, but in order for me to set specific conditions for you, I need to ask you some questions. So it's not about the case, so please do not talk to me about what you believe the facts are in the case. Do you understand?
Yes, ma'am.
All right, so have you ever used any type of drugs in the past?
In the past, yes, ma'am.
And what would that be?
Mainly marijuana and methamphetamine.
Have you ever in the past been diagnosed with any type of mental health issue?
Depression.
And have you ever received any medication for that?
I'm here in county, yes, they give me medicine. I'm receiving medicine.
And if you were released on bond, do you have a place to live?
Yes, ma'am.
And is that by yourself or is that with someone else?
This is my dad.
Are there any minors in the home?
No, it's just my dad and his dogs.
So there are minors in the Okay. All right. Is there anything else from either side?
Not from the state.
Nothing, Judge. Thank you.
All right. So in cause number 2025 CR 00553. And I'm sorry, what was the previous bond on these?
10,000.
10,000. All right, and 2025 CR 007553. The court is going to note that the court received information that you were previously in the hospital, and that was the reason for your missing your court date
Yes,
with
ma'am.
the presiding judge at that time. The court is going to set your bond amount at 10,000. The court is going to order a referral to Center for Healthcare Services. And there's to be 60 sober support meetings in 60 days. And in cause number 2024 CR 012424, the court is going to set your bond at $12,000. There's going to be a referral to Center for Healthcare Services. There's going to be 60 sober meetings in 60 days. And state, in these cases, were you able to tender an offer?
We did talk about an offer and tender an offer, Your Honor. It was today only, so it will be reevaluated later.
All right. So,
And I did explain that to my client, he understands.
And we did give acknowledgement of discovery.
Yes.
All right.
I signed that earlier.
all right, Ms. Ferguson, set this for next week for a plea deadline date. And then after that, if there's no agreement that is reached, you're going to have a jury trial. It's going to be a quick turnaround. You understand?
Yes, ma'am. Thank you.
You're welcome. What date? August 5th?
Yeah.
All right, August 5th will be your plea deadline date.
Judge, would it also be possible to get him sort of pre-screened for the drug court program?
Yes. You'll need to speak to them about that.
Okay, I'll talk to Judge Glenn and see if we can get that set.
All right. And Norma, there'll be a referral to felony drug court. Just let them know it needs to be a quick turnaround.
Yes, ma'am. I'll reach out to them today.
All right, thank you.
Thank you.
Oh. Okay.
Have a good day.
All right, thank you. You too. Deputy Laura, I'm so sorry. Can you reprint this one on Moses? Yes, because I wrote the wrong number on it, I think. I thought that was Arredondo's. Who's here on Dalen Newman?
Ready, Your Honor.
All right, and are you all ready to proceed with the motion to revoke?
There.
Court is calling 2024 CR 012811. State versus Dalen Newman. Can I have parties announced?
Megan Galloway for the state.
Peter Calderola for Mr. Newman, Your Honor.
And are you Mr. Newman?
Yes, Your Honor.
Thank you. Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2024 CR 012811 for the offense of theft of a firearm on February 4th, 2025 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
Judge, really quick, there were two.
There too?
Yes, so there's the one, the theft firearm, and then there's cause number ending in 001217W. That's a family violence.
All right. And then we're also proceeding then on 2025 CR 001217W.
Okay, and
just one moment. And that cause number, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2025 CR 001217W for the offense of assault, bodily injury, family household on February 4th, 2025 for a period of 1 year? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
we will be proceeding on the same violation in each cause number, and that's violation of condition number 4. In Bear County, Texas, the defendant Dalen Newman did then and there fail to report to the supervision officer as directed for the months of March, April, and May of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
State, do you waive the other?
The remaining.
No objection, Your Honor.
All right, in cause number 2025 CR 001217W. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. And in cause number 2024 CR 012811, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Be true.
Yes, court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and just so the court is aware, this is the defendant's first MTR, and he was placed on deferred education in each cause on February 4th of 2025. And so the agreement for the court's consideration is to deny the state's motion, continue the defendant, but alter and amend his conditions to include a TAP evaluation to be done in custody, weekly reporting for 60 days upon release, the moral recognition therapy course, and a 30-day jail sanction to run concurrent with the days that he's in custody awaiting the TAP evaluation.
All right.
That was our understanding. Your Honor.
All right, do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Dalen Newman.
Why are you not recording?
I was going down the wrong path. I was kicked out and I was homeless and I couldn't
Kicked
have
out from where?
my household.
And who's in that household?
My mom, my little brother, and my stepfather.
So why did they want you out?
Because I wasn't able to find a job in the time that I needed to.
Why were you not looking for a job?
I was looking, but I wasn't applied to or recognized in the time that I was needed to be recognized for work.
All right, so here's the thing, and you correct me if I'm wrong. Usually parents love their children, and if they're doing everything they can to find employment, normally they won't kick them out of the home. So what else was going on in the home?
There was nothing else going on in the home, Your Honor.
So you're telling me if your parents were to testify, they're going to say, we just put him out because he didn't obtain employment, that he was doing his best. He was going out every day trying to find employment, but he just couldn't do it. So we kicked him out because no one would hire him. You're telling me that's what your parents are going to say?
Yes, Your Honor.
All right. Then let's have the parents testify to tell me what was going on in the household. I want to know. Because I find it very strange that parents would put somebody out, a child who's doing the best they can, going out, seeking employment, and then they would put them out because they're unable to find employment. So.
Yeah, I do not believe that his parents are present today to testify to that.
Oh, I mean, we can always recall this back. We can recall this back for Thursday. And if there's no objection, his parents can appear by Zoom.
Yeah, I believe that Mr. Newman has relayed to me. I believe that his parents are going to allow him back into the home.
Oh, no. I want to know why they put him out of the home. Because if you have parents who put a child out of the home who is doing his best, seeking employment, and I find it just strange that that's the only reason why they would put him out. So I want to know if that's the only reason why they put him out.
Understood, Your Honor.
And they'll be placed under oath if they appear. And then the court will hear that. So we can recall it for Thursday for your parents to appear. So that they can tell me under oath why they put you out of the home.
May I have a brief sidebar with my client, Judge?
Sure.
Before we proceed?
All right, who's the attorney for Jeremy Lopez and Isidro Garcia? All right, and counsel? Yes.
After conferring with my client judge, he expressed to me that part of the reasons that he was not allowed in the home anymore.
Well, I mean, I want to hear from him
Okay,
because he's told me the only reason why his parents put him out of the home is because he was looking for employment and he couldn't find employment. I just find that hard to believe that a parent would do that if somebody is doing what they're supposed to be.
Mr. Newman, do you want to explain to the court what you just expressed to me?
Yes, sir. I said that I wasn't meeting their obligation, as in finding a job in time, as I failed to meet y'all's obligation in the 30 days.
What else did you tell me about probation?
Probation, that they said that I was failing to attempt to pursue my probation, as in checking in.
Well, no, I mean, you're still saying the same thing. You're adding, but you're still saying the same thing. You're saying that the only reason your parents kicked you out of your home with them is because you could not find employment. That's what you're telling me. That's what I'm hearing. If I'm hearing something different, let me know.
You're not.
All right, so you can have the parents here by Zoom and the reason why I'm doing this is because maybe that's not the right placement for you to be at home with his parents if they're putting him out because he can't find employment and he's doing everything else perfectly. So they can appear by Zoom.
All right, Judge, I just do not have any contact information for his parents.
Oh.
I will talk to Mr. Newman.
All right.
See if I can get them available. However, I do understand as well that in the court summary, it did state that the parents were, I don't know if they were available to be contacted.
Okay. All right. Well, he should have their contact information to see if he's been living with them. All right.
Right, Judge.
All right. Thank you. Lopez? If you come down, court is calling 2025 CR 007-014, State versus Jeremy Tyler Lopez. Can I have parties announced?
Megan Galloway for the state.
Danielle Cranberg for the defense.
And are you Mr. Lopez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that state is in compliance with discovery. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a building, that the state jail felony range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine? If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you enter agreement will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counselor, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
Mm, um,
So anyway, you have a plea bargain agreement with the state. Do you understand that?
yes, ma'am.
Outside of that agreement that you've reached with the state, has anyone promised you anything else?
No, ma'am.
All right. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 198 days in the Bexar County Jail under 1244. There's a $1,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge, I believe the intention for the state was for it to be a judgment sentence.
All right, state, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting no contact with city, community, church. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? Guilty, not guilty, or no contest?
Guilty.
We had discussed no contest.
No contest.
All right, do you understand what a no contest plea means?
Yes, ma'am.
All right, state, any evidence to support the plea?
State offer states one in attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We'd ask the court to follow the agreement.
All right, why are you doing this? How old are you?
I'm 23.
All right, according to the police reports, you're causing disturbance at your parents' home, and you're committing burglary of a building at this church. Why are you doing this?
So I go to that church, at night, because it's an amphitheater church, and, I just like to walk the stage and listen to music. That's what I usually do. I go there to, free my mind at night. And it just so happened that the time that I needed to use the restroom, I saw that there was a door open. And I didn't plan anything. I just, was just curious why the door was open. And it's just something that I know I made a mistake.
Well, I mean, you made choices that were not good choices.
Uh, yes, that's right. But I was really just curious. I did not plan anything like that. And it's just something that I ended up walking into.
And then they said that there was money missing. They said there was money missing after you had walked into the church and left. So it's more than just walking and being curious. You understand?
I believe that's the mistake that.
Well, I mean, did you take money or not? Because they're saying that you walked in, there was money before you walked in, and when you left, money was missing.
Yeah.
$619.50 was reported missing from the church cafeteria. How far did you go in school?
I made it to the last month of my senior year. It
Why?
was a school in the country of North Dakota, in the very country there. It was a school where there's only 10 kids in my class.
Mhm.
And the same 10 kids attend that same school from preschool to their senior year. And so when I went back to my senior year there, they were really judgmental of me. My parents are part of the military, so I lived in a lot of different.
Well, let me ask you this, because there are a lot of people who have parents who are in the military. Your mom said that you have been causing disturbance at the home.
And I could tell you that my family that I've explained to that the way that my mom is being, they could say that a lot different of a story than what she's trying to.
Well, you're 23. You need to get a place of your own
That's
instead of
because,
living with your mom.
My bad for interrupting. I was 19 when I first got incarcerated. And I was recently released a few months ago. So that's the reason why I'm 23 and still there now, because I was 19 before I was incarcerated.
And what's with this teardrop?
It's for a lot of things. It's not anything bad.
What is it for?
I feel like I've been put into a lot of positions where I've been forced to burn a lot of bridges that I've had. And because of that, I've lost a lot of people in my life.
So here's the thing. I really don't have a problem with tattoos. People can do whatever they want to, but teardrops beneath the eye have certain connotations. I don't know why people start tattooing their face. If you want to tattoo your face, fine, but your job prospects are going to be limited. And it's going to be limited to maybe being an actor, maybe investing in concealer, maybe working with a band, or maybe who knows, there'll be some great person who will see past the tattoos. So what is his criminal history?
I believe he's currently on felony probation in another county, Judge.
All right, and what are you on felony probation for?
And aggravated robbery.
Ah, thank you. Now I know what's going on. This is why I ask these questions. So the court is finding him guilty. The court is going to sentence him to 198 days in the Bexar County Jail under 1244. Give you credit for any time served. There's $1,000 fine. time and money will run concurrently. There's to be no contact and restitution, if any, to city, community, church. And the court will show that this judgment is satisfied so that the other county can come pick you up. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You better do better. Otherwise, you're going to end up the rest of your life in somebody's prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you. All right, we are going to take our recess. Anyone here who has plea paperwork that's been completed, you can appear by Zoom.